day, viewers, and a very warm welcome to this episode of the Indian Lawyer Legal Tips. I am Sushila Varma, advocate and chief consultant with the firm. Today, we plan to discuss something which is extremely important if you are looking at approaching a court of law for redressal of your rights. This is what is known as the limitation law. The limitation law in India is prescribed in the statute called the Limitation Act 1963. Now, what is the law of limitation? Simply put, the law of limitation prescribes the time limit for different suits within which an aggrieved person can approach the court for redressal or justice. The suit, if filed after the expiration of the time limit, is struck by the law because of the law of limitation. Hence, if you want to go to court for a redressal, you must ensure that you meet the timelines that are set by the law of limitation. Now let us understand what is the purpose of the law of limitation. The purpose, put simply, is that the primary objective of the limitation law is to ensure fairness and prevent injustice that can be caused by delayed claims. The law provides a remedy for every breach of legal right, provided the action is taken on time. Now, we have to understand another very important aspect in the law of limitation, and that is the difference between period of limitation and prescribed period of limitation. Now, when we say prescribed period of limitation, we are referring to the schedule that is there in the Limitation Act 1963, where every remedy that is allowed under the law has a prescribed period of limitation, and that period has to be followed. But now, what is the period of limitation? When we say period of limitation, we mean that once the cause of action starts, then the limitation will start running and it does not stop. Hence, if your cause of action has arisen today and you have the right to take an action, the limitation will start running from today till you cover the 3-year period or whatever period is mentioned in the statute. Now, the prescribed period of limitation has been defined under section 2J, and it means the period of limitation computed in accordance with the provisions of the Limitation Act. It also includes extensions, exclusions, or any special provisions that may be applicable in computing the limitation period. Now, one thing that was obviously going to come to the minds of the viewers is what happens if I miss the period of limitation. If you miss the period of limitation in an original suit, you don't have any remedy. But if it's an appeal or an application and you have missed the bus, then in such a case, you can approach the court in a Section 5 application in which you will try to show the court why you have sufficient cause for not being able to meet the limitation period, and you can then request the court to condone the delay in the filing of an appeal or application. Please, however, note that this application has two aspects. One, that you have to show sufficient cause, and secondly, you have to explain each day of delay. It is not as if you can just give a blanket reason for the delay that has been caused. But the most important aspect that you must be aware of, dear viewers, is that this relief is completely discretionary and it would depend on the judge as to whether or not he would be interested in condoning the delay. Many a times, a delay of even 3,000 days has been condoned in the Supreme Court of India, where the judges have felt that it is in the interest of justice. But there are times when even 30 days has not been condoned. So please be vigilant about your rights and your remedies. Now, one thing that would probably come to a litigant's mind is what and how do I plead sufficient cause? There is no straitjacket formula for accepting or rejecting an explanation that has been given by an applicant or appellant for the delay in taking the steps. That is why I have been trying to say that whatever explanation you are giving the court has to be logical, something that will appeal to the mind of the judge. It has to be bona fide, and it should not show that you have been negligent or you have been or you are guilty of inaction. Let us now examine a case law that has been passed by the Supreme Court in the case of collector land acquisition versus Cartigi and others. It's a 1987 case in which the Supreme Court was of the opinion that the court should adopt liberal and justice-oriented approach for the purpose of condonation of delay. The court held that ordinarily a litigant does not stand to benefit by lodging an appeal late. However, refusal to condone delay can result in a meritorious matter being thrown out at the very threshold, which at times can cause justice being defeated. Hence, this delay can be condoned only when the cause would be decided on merits after hearing the parties. Dear viewers, I want you to understand the importance of limitation, because the purpose of limitation is that it encourages diligence. What it tries to do is do away with delays which result in unfairness, and it ensures prompt legal redress. Limitation tries to ensure certainty and thereby gives protection to the citizen of India from perpetual litigation. Most importantly, it brings a finality to legal matters, thereby bringing peace to the litigant or to the person who has been litigated against. Now, what I want all viewers to understand, that limitation, when it expires, does not extinguish one's right to a remedy. You will continue to have a right to the remedy, but the only thing is that you cannot do it through a court of law. Hence, if somebody owes you money and you want to go to a court of law and you have failed to follow the limitation period of 3 years, you lose your right to recover the money through the process of court, but you do not lose your right to recover the money from an out-of-court process. Now, another important aspect of the limitation law is that there are certain cases in which there is no prescribed period of limitation. In such a case, there is an Article 137 which says explicitly that when there is no period of limitation provided in the schedule, then the period of limitation will be deemed to be 3 years when the right accrues. Now, moving on to a Supreme Court case, Basavaraj and another versus Special Land Acquisition Officer, 2014, the Supreme Court held that even though limitation harshly affects the rights of a party, but it has to be applied with all its rigor when prescribed by a statute. The Supreme Court has gone on to state that equity is not a ground to extend the limitation by condoning delay if there is no sufficient cause. In another case, Popat Bahiru Govardhane versus Land Acquisition Officer, 2013 Supreme Court, the division bench of the Supreme Court observed the Limitation Act applies to the courts and not quasi-judicial authorities. In conclusion, I would like to sign off by saying the primary object of the Limitation Act is to place a bar on the time period wherein the distressed party can institute a suit, application, appeal, etc. The term limitation should be literally translated as the term itself states, that is, confinement or circumstances which are limited. Condonation of delay of a remedy is something which is given by the law, but please note that it is always a discretionary power that can be exercised by the court of law. Dear viewers, please understand that there are a few aspects of the law which are extremely important, one of which is limitation. If you fail to approach a court within the period, you will lose your right for good as far as court proceedings are concerned. Please therefore share this video with as many people as you can, because we are trying to create social awareness regarding the laws of India. If you have found this episode useful, please like, share and subscribe, and please help us to reach as many people as we can.